Welcome today welcome and good afternoon on behalf of UCLA Law School and the Epstein Program in Public Interest Law and Policy here at UCLA. I'm Karen Wong. I'm the Executive Director of the Epstein Program, and I'm delighted to host today's wonderful event. This is our first spring 2021 Margaret Levy Public Interest Fellow lecture, and I'm going to leave the formal introductions and welcome to our dean. I'll be back at the for the Q&A portion that follows the lecture, but I am now going to turn the program over to our wonderful dean, Jennifer Mnookin, who, thank you, Jennifer, first of all, for your support of this program, specifically in the public interest community at the law school. And I'm going to turn it over to you to kick us off officially.
Terrific. Thank you so much, Karen. And hello, everybody, and welcome. It's my tremendous pleasure to welcome you to this latest, truly incredible series of lectures by our distinguished Margaret Levy Fellows, presented by the David J. Epstein Program in Public Interest Law and Policy. These lectures are always some of the real highlights of the year at UCLA Law School. Our Levy Fellows include top thinkers, advocates, and drivers of innovation who are on the cutting edge of public interest law and policy. Obviously, I am sorry that this can't take place in person, as so much else cannot take place in person right now at UCLA. But I'm also so pleased that we are able to go ahead and do this virtually. And I know that this is going to be as inspirational as ever, even if we can't be physically in a classroom together. I think there's going to be a tremendous presentation ahead. Before we continue, I do want to acknowledge that UCLA Law sits on the traditional, ancestral, and unceded territory of the Gabrielino Tonka peoples. As members of a land-grant institution, we at UCLA pay our respects to the ancestors, elders, and relatives, past, present, and emerging. I also want to thank Margaret, or Maggie Levy, for the vision and the support that drives this signature public interest program. Maggie, we really appreciate your making this series possible and your support of our public interest programs in our law school. Today, I'm very pleased to get to introduce our first spring 2021 Levy Fellow, Marbre Stahly-Butts, one of the country's leading activists for racial justice and criminal justice reform. Her commitment to advocacy and to policy development is truly an inspiration. Marbre is Executive Director of Law for Black Lives, a women-led national network of thousands of lawyers committed to change in the legal profession, promoting movement lawyering, and representing impacted communities. Marbre, we're truly honored to have you at UCLA Law School this week, albeit virtually, and we're delighted that you'll be participating in several meetings and presentations. Today's lecture is entitled Lawyering for Liberation, Movement Lawyering and Black Lives Matter. And there's a great deal that I know we're all going to learn from you, especially in this ongoing moment of critical national reckoning over systemic racism, including our own examination of how the legal profession, both generally and here at UCLA Law School, can continue to work toward increased equity, diversity, and inclusion. Marbre Stahly-Butts earned her BA in African American History and Human Rights from Columbia University, her master's degree in African Studies from Oxford University, and her JD from Yale Law School. As a Soros Justice Fellow at the Center for Popular Democracy, she organized and worked with families affected by aggressive policing and criminal justice policies, and she aimed to create meaningful bottom-up policy reforms. She's also worked with the Bronx Defenders, with the Equal Justice Initiative, and the Prison Policy Initiative. And she's also served as an organizer and teacher in both Zimbabwe and in South Africa. I know her message and her own story are going to be educational for us and inspiring, especially as we consider the current national state of affairs. Lawyers play critical roles in fighting for a more just and equitable society, though lawyers don't always serve in roles like that. And also in social movements, lawyers are just some of the many players who are positioned to propel larger movements for change. Marbre, thank you so much for joining us this week and for today's lecture. Now, everybody, please join me in giving a virtual warm welcome to Marbre Stahly-Butts.
Thank you so much. I'm so humbled and grateful to be in this conversation, and so grateful. I wish that we could be in person, and I'm really sorry that we're not. But I'm excited to talk to y'all and for the week ahead. I guess it's a month that we're going to be in conversation. So there'll be other talks and conversations. But I want to just thank you so much for creating this opportunity and creating this space for us to have these conversations. And thank you for the introduction. I'll start by I'm going to share my screen. I have a PowerPoint. Shout out to Canva that has made me into like a PowerPoint genius. But really want to engage in like a kind of a half an hour just presentation around movement lawyering and abolition and radical lawyering, and then really want to have a conversation. Are folks looking at my screen? Can y'all see that? No. Sometimes I show like baby pictures on accident instead. Great. Beautiful. So I wanted to start by thanking folks. I have to firstly say thank you, Kaylin, and the folks who really organized today and made sure that it went off without a hitch and brought students to have conversations and all of the things. So just thank you for all the labor and love that went into this. I also have to say that I have like an intellectual crush on like half of the UCLA faculty. And so they've been examples for movement lawyering, for critical race theory. Since I was in law school, honestly, there's been just like real leaders in terms of progressive and radical progressive thought that has happened at UCLA. And so I'm just really grateful for the example of folks like Kimberly Crenshaw, Sunita Scott Cummings, Betty Hung, and Robin Kelly, who was one of my first professors when I was an undergrad. But really I think they really set the way in the conversation around what it means for lawyers to show up and be part of a progressive and radical left. And really, I have to say, like, I often reference them both in law school and throughout my career as examples of that. And so I want to just say there's lots of stuff I'll probably say that may feel more radical or progressive if you aren't at UCLA, because y'all have been exposed to some of the top thinkers who have really been thinking and holding this political line for a long time. And so I also stand on their shoulders, and I'm so grateful for their work. So I'll start by saying that. I also, I want to take a few minutes to kind of acknowledge the moment that we're inside of. I think today is the anniversary and signifies a few major things that are happening across the globe that I think really frame this talk in a really important way. So one, of course, is that today marks the beginning of the trial for Derek Chauvin, who is the person who killed George Floyd in Minneapolis this summer. And many of us know that no matter the results of that trial, that the killing of young Black people at the hands of police continues unabated across the globe. This morning, I saw a videotape of a 3-year-old being wrenched from her mother's arms while she was tased in New York State by a police officer. And so the reality that these trials, although important political moments, don't actually change the systemic outcomes of the country we live in or the systems that are harming and killing and exploiting our people. Also, just last week, the U.S. House of Representatives approved the George Floyd Act, which ironically would not have actually saved George Floyd's life. And so again, responded to systemic outrage, to protests across the world and in this country with procedural answers to what are systemic issues. And so I think that's another really important kind of framing for this moment in this conversation. And then lastly, today is the 50th anniversary, March 8th, 1971, where a group of activists broke into an FBI office in Philadelphia and stored thousands of documents to prove that the FBI was waging war against the front lines of the anti-war movement and the Black liberation movement. And so I think that these three events, the reason why I want to frame the talk with them, I think they really kind of triangulate a few realities that are at the heart of this conversation. Number one is that the courts cannot and will not redeem our systems, which are not just broken. They are in fact working how they're supposed to. They are corrupt systems, right? And so court procedures, trials will not get us free, and it will not redeem the systems in which we operate. Secondly, that our current political apparatus, the Senate, the Supreme Court, that were actually formulated and created as ways to maintain and uphold slavery, are insufficient to meet the challenges and the radical needs of transformation of this moment. And so we continue to see the Senate and the House political leaders leaders put religions on what are gaping gunshot wounds. And I think the George Floyd Act is an example of trying to come up with procedural solutions to what are systemic issues. And lastly, with the anniversary of the robbery in Philadelphia, we know that the law does not define justice or righteousness, right? That the law is not the confines in which we should understand what is just or what is right. And so I want to start with kind of that, because I think it really does underlie what it means to be fighting for liberation and for transformation in this moment. My plan for the next, I'm going to set my alarm because I come from teachers and preachers, and sometimes it's an hour later and people are confused about what happened. So let me make sure that I'm on schedule. So my plan is fourfold. Number one, I want to introduce y'all to Law for Black Lives, which is the organization that I'm part of and was one of the co-founders of. In a moment, I think much like this one, sorry y'all. In a moment much like this one, of massive, massive protests across the country. So I want to do that. I also want to introduce y'all to movement lawyering, which y'all know a lot about because you guys have some incredible scholars at UCLA who are at the forefront of this. But just to ground us in what we mean by movement lawyering and what its relevance is to this moment. And I think a remix in some ways on movement lawyering, not in the abstract sense, but movement lawyering as it really applies to radical Black movements, which is the position from which I operate in. And then thirdly, abolition. So just a quick primer, so that we can really understand what transformative reforms and change looks like and what that demands of us as lawyers and legal workers who are trying to navigate that space. So that is my hope that we can cover that together. So Law for Black Lives was founded about 5 years ago in, as I said, the aftermath of another series of mass uprisings across the country and the globe, really, after the killing of Michael Brown and Eric Garner and Sandra Bland and many, many others. And so there was a series of, I think, assessments that were made by the founders of Law for Black Lives at that moment, which I think remain really relevant even today. So the first assessment is that there really is a lack of infrastructure for radical lawyers. And this was something that I think we really saw when we were at the front lines in Ferguson and in Baltimore, that when young, often Black, often queer, often working class and working poor folks were on the front lines, legal organizations didn't have their back if their demands weren't aligned with their own interest. And so the reality of a real need for a radical, and we'll talk about radical more later on, but radical meaning kind of grasping at the roots, infrastructure that actually supported young radical folks who are on the front lines. We also saw, I think, a stagnation across the board in the legal field, a lack of innovation, a lack of risk-taking, a lack of boldness around legal interventions that were happening. We also saw severe isolation amongst lawyers who wanted to do movement work, who felt alone, who felt often isolated in their own organizations or their jobs, and who were not necessarily taking care of themselves or their politics in a way to really be of the most support. And so we saw a lot of, I think, fatigue amongst movement lawyers. We also saw a lack of explicit politics and political development for lawyers. And so there wasn't really a place for lawyers to go to sharpen their abolitionist politic or their anti-capitalist politic, or even have them want to show up for movement. And so we saw a real need for deep political education that extended beyond kind of traditional CLEs, right, legal skills, but actually politics. And then lastly, we saw the real need to develop a movement lawyering praxis. And so how do we actually movement lawyer in a way that is collaborative, that builds on the theory as well as the practice of it? And so we kind of diagnosed a lack of space for movement lawyers to really practice their craft and develop their politics. And it was out of that the Law for Black Lives was developed. And so we often tell the story of, there were a lot of lawyers who were gathering in Ferguson and Baltimore where there were protests happening. And it was the same lawyers who were kind of having the same concerns and complaints. And so we decided to have a conference to bring folks together to kind of think through and talk through how we might support each other. And I think we expected maybe a few hundred people to show up to that conference. And in fact, over 3,000 folks registered and over 1,000 made their way to New York. And so it was clear to us that there was a deep hunger and desire to be in community around what it meant to show up in this kind of moment, in this iteration of radical movement for movement. And so we were founded at that point, and we had three kind of major goals. One was to transform the law, that we recognized that the law as they stood were meant to target, to isolate and often to harm Black and brown and poor people. And so how do we actually transform the laws? We also work to transform the legal field. And so we recognize that often the legal field and lawyers specifically serve as gatekeepers to power. And so how do we think about and reconfigure lawyers' relationship to movement and to power, such that we're actually part of the solution, not just the problem. And then lastly was to support Black base building groups. And as what I'll talk more about, our theory of change is that change happens through organizing. And so how do we support with our resources, with our knowledge and our information to build the power of base building across the country? So those were our three major goals. We did that through a movement lawyering lens, which I will talk more about. We also are an explicitly political organization. We were founded in the files of the Black Lives Matter movement, which is the most recent iteration of the Black liberation movement. We believe in abolition and Black queer feminism, and we embrace those tenets as key to our politics and also how we move through spaces. And we are fighting for reparations and abolition as kind of key parts of our organization and what we see our utility as being. So I'm going to start by just defining movement lawyering, and this is a quote that I borrowed from Betty Hung, and also kind of a framework. But we see movement lawyering as lawyering that supports and advances social movements defined as the building and exercise of collective power led by the most directly impacted to achieve systemic, institutional, and cultural change. And there's a few things that are really important in this definition, just to name. So number one is that movement lawyering is about supporting and advancing social movements. So the idea is not centering the law or supporting legal strategies, is how do we actually build the power of movements as with the law as one of many tools. Another important part of this definition is power. And I think just generally, I find that in law school, at least when I was in law school, we almost never discussed power. It was like the invisible elephant in every room, that we understand that power relations structure every single decision that we read, structure every conversation that we're having, but we so rarely point out and name where power is emanating from and what that means and what are the repercussions of where power lives and where it emanates from. And so I think this idea of a power analysis is so central to movement lawyering. We have to think about and talk about power in order to shift it. I also think this idea of systemic, cultural, and institutional change is important. That very often when we lawyer for an individual client or a single result, but movement lawyering actually is considering and thinking about and fighting for a systemic, holistic shift in both power, but also in cultural and institutional realities, right? And so movement lawyering is kind of the zoom out of how do we support not just individuals for just outcomes, but how do we actually lawyer towards systemic change for movement. And I love this. This is also from the Betty Hung article, but they talk about kind of how do we ground movement lawyering. So it's grounded in a place of humanity, that we recognize as movement lawyers that the law is just one of an assortment of tools. And very often it's not the most important tool in a toolbox for change, right? And so the law can be a useful weapon, but if it is centered as the only weapon, it really limits our ability to enact change. We also say that movement lawyering is grounded in a place of love, that it takes a relational approach, that it's about building with other movements, it's about building with communities and people, it's about how do we show up in a way that actually allows for the leadership development and the growth of our communities in meaningful ways. And so it is deeply relational, it comes from a place of love. And it's also grounded in courage. It's being willing to relinquish our own privilege and stand up for justice. And so recognizing that these same systems that privilege lawyers are the same systems we have to dismantle. And that takes real courage to actually be engaged in dismantling your own privilege in any given moment. And one of the key characteristics of movement lawyering is that it has a very clear theory of change. And so that is how we think change happens. And I think implicitly in law school, you learn a lot about change happening through Supreme Court cases that are famous. We learn, I think, throughout history, kind of the MLK, Malcolm X version, that change happens when like one charismatic leader stands up and takes the lead, right? Or one brave person, like a Rosa Parks. And the theory of change behind movement lawyering is that it's in fact through movements, through organized people that change happens. But I think this is really important because lots of different theories and practices don't have theories of change. And so how we think change happens matters because it dictates how we actually move as lawyers and what we prioritize. And so this is a Emil Cabral quote, that every practice produces a theory. And I think this is really important because very often in law school, we're taught to be kind of apolitical in how we practice law. But the reality is that in being apolitical, we are perpetuating the same structures of capitalism, of patriarchy, of heteropatriarchy, of racism that come before us. And so if we don't exercise and operate with a clear theory of what we think we're doing and why we're doing it, we are destined to recreate what's come before us. And so I think it's really important that as lawyers, as movement lawyers, that we are actively engaged in producing in cultivating and in evolving a theory of how we think change happens and what we see our position in that change being. And so to that point, as I mentioned, movement learning has a really clear theory of change, and that is that it is through directly impacted individuals taking collective action, leading their own struggle, and gaining power to change the conditions that things change. And I think we base that on a series of things. And we really reject the idea that it's the law that enacts change. And so, as I said, we often learn in school kind of this Brown v. Board theory of the war, that it's when you win a big Supreme Court case, all of a sudden change happens, and it's through lawyers and legal workers and legal actors and courtrooms that are the sites and the battlegrounds of social change. And the reality is that that's not the case. And I think we do a study of history and think about different movements in which it's been people on the streets, people putting their life on the line that have been at the forefront and the vanguard of change. And so we reject theories of change that center lawyers. We understand the law as mitigating harm. And so if you don't have a house, if you're being evicted, if you're standing before a criminal court, there are ways in which lawyers and the law can keep you out of a cage or in your home. And that's really important to mitigate harm and create space for movement, for folks to organize. But it is not that the law will save us, it's that the law can create space for us. We also see the law as one of many tools, but we understand the limitations of the law. And I think this is a really important kind of point about movement lawyering, is that we understand the law in this country as being rotten versus broken. And I borrowed this actually a lot from critical race theory, which for me was kind of a lifeboat when I was in law school. But understand that the law was never created to protect Black and brown people. It was created in some ways to legitimize the oppression of Black and brown people. And so understanding the limitations of a law that really is not just broken. The criminal legal system is not a broken system. It's operating exactly how it's supposed to operate, right? And so how do we actually address and use the tools of the law to start to create space for folks to actually transform these institutions and these legal practices? And so I think movement lawyering, again, by decentering the law, allows us to think about what are other ways we can enact change. How can we center folks like organizers and communities as really the heroes in their own stories of social change, as opposed to very often who is heroized, which are lawyers and legal workers. And as I mentioned, I think this theory of change really looks to historical case studies to make its point. And so if you look at everything from slavery to union rights, to desegregation, to now de-incarceration, the reality is that none of these major social shifts resulted from court cases or from the actions of lawyers or even lawmakers. That if you look at slavery, for instance, it required a civil war to actually see a shift. And there were numerous cases, whether it's Dred Scott or Plessy v. Ferguson after the war, that in fact tried to enshrine slavery in different ways. And so it is through the actions of individuals, of folks who were brave enough to put their bodies on the line, who demanded through an abolitionist movement that lasted decades, and then a war that lasted for years, that freedom was actually achieved. And the courts were actually behind, not in front of that social change. I think the same can be seen for union rights, that it really is the actions and the work of strikers, of folks who literally risked their lives and their livelihoods to demand rights for workers, not the Lochner court, not a court that was often behind and pro-corporate in its shift. And we see a shift in the court as a result of a shift in culture and a shift in organizing. The same is true for desegregation, that although we see Brown v. Board, the reality is that many of us go to schools that are as segregated, if not more segregated, than the schools pre-Brown v. Board, right? And so we know that courts are not self-actualizing engines of change, that it requires people and movements to implement change, even when courts make them. And of course, with de-incarceration, we see a court that is concerned with too much justice, as they say in the McCleskey case, and not at all in the front of a movement to decarcerate this country. And it is often folks who are incarcerated who led that fight. And so over and over again, despite this narrative that we learned in law school and before about lawyers being the heroes of social change, it is in fact people who have to live through the consequences, who are often at the forefront and who are able to both enact and sustain social change. And I think, there's a lot of harms of putting lawyers and legal mechanisms and legal fights at the center of social change. One is it limits our imagination. It limits what we think is possible if the confines of what's possible really happens to the court. So that's number one, is that what we imagine to be possible is really limited. And I often say that I think that law school did a trick on me in terms of my imagination being limited after law school. That I think I went in with much more radical ideas of what was possible. And the law is kind of this constant barrage of limiting your possibilities, right? It's always find the no, find what's impossible, find a precedent that establishes this. And so there's all these ways that the law actually is a limiting structure for us to be inside of. Secondly, it creates dependence. And so the reality is that when lawyers are constantly intervening, when they're constantly the center of social change, it creates the impression that without a law degree, you can't do change. It creates communities that are dependent on litigation as a way to get themselves free. And it creates societies that don't actually create or think about new ways to enact justice, right? It atrophies the muscles of justice and of self kind of creation. And the law does that, I think, via creating these situations in which everyone thinks, oh, let's just wait for the court date to happen, right? It creates dependency in that way. And then lastly, when we center the law and lawyers as kind of the heroes of social change, it also sanitizes and legitimizes legal structures and processes. So the reality is that our criminal legal system is an illegitimate system. It is born from slavery, and I'll talk more about that. But when lawyers play inside of it, when we rely on it as the kind of key site of struggle for abolition or for reform, we are in many ways legitimizing the system as one that is worthy of reform as opposed to abolition, right? And so I think there are ways in which by centering the law, we really do, we legitimize the systems that are often created to harm and kill Black people, brown people, and poor people. And it is when we rely on and when we build up organizing and other ways that change happens, we see that there are more possibilities, there is less dependence, and there also are kind of more creative, bold, transformative, different structures that get built up in the place of what exists now. So that's kind of my movement lawyering 101. I think y'all have, I'm sure seen and read much longer and much more beautifully explored kind of explanations. But I think it's important for us to ground in that because it is from that place of understanding that it is the law is one of many tools, that social movements should be the dictators of legal action and should be at the center of them, and that change happens when we empower and support organizing efforts, that at least I came to lawyering in many ways. And I often say that I am not just a movement lawyer, I'm in many ways on assignment for a specific movement, that I came into lawyering with a desire to be part of a radical Black liberation movement, that I understood my own legacy and history of bringing to a moment of wanting to use the law as a tool to get my people, and by extension, all people free. And I think this is important because when I kind of first started reading movement lawyering scholarship, it always felt as if movement lawyering was divorced from movement. It was like this kind of body of theory and of thought that was not attached to any specific movement, right? And that it's really important to name that there's I think an importance of attaching ourselves to a movement. What are your politics? What is the movement that you are lawyer on behalf of? The Trump movement has lawyers who are quote unquote movement lawyers. But what does it mean to actually lawyer for a radical left movement? And so I often think about kind of Black Lives Matter as an extension of a long-standing movement for Black liberation. And it is, I think, whether it's kind of the civil rights movement that's been sanitized, there's always been a far left from the abolitionist movement of the 1800s through the populist movement, through the kind of current, civil rights movement. There's always been a far left that has demanded a series of things, and those things haven't changed drastically. Among those things is one, abolition, and so the abolition of slavery was the beginning of that, then the abolition of Jim Crow, and now the abolition of the prison industrial complex. But there's a clear lineage of demands from the radical left movement of abolition in the 1800s. Secondly is anti-capitalist. There's been a long tradition of anti-capitalists inside of Black radical movement that essentially says we cannot continue to live in a capitalist society and ever be truly free. That racialized capitalism demands a degradation, an oppression, a disposability of people that is counterintuitive, and it cannot exist alongside of radical liberation. This is also a movement that embraces Black queer feminism. This one is a bit newer. I think that we see a lot of patriarchy in past liberation movements, but I think the kind of intervention of the last decade has been around how do we actually integrate Black queer feminism and intersectionality into our analysis and into our movement. And then reparations, which I think is not only a demand, but it really is a framework that has framed every Black liberation struggle from the end of slavery on. And that means we have to assess past harms, we have to reckon with them, and we have to address them in a meaningful way. And so I see myself as a movement lawyer who is very clear about my politics inside of a Black liberation movement. And so I'm very clear that my allegiance is not to the law as an abstract concept. It's not to the Constitution as a document. It is really to the liberation of all people, and centering the liberation of the most marginalized Black and brown people as the beginning of that liberation and that struggle. And that I think matters. And I say that in part to disregard and to kind of derobe myself of what I think is often a facade of objectivity that is really oddly fetishized inside of law school and inside of the legal profession. And the reality is that nobody is objective, but objectivity is especially hard to obtain, I think, as Black folks, as women, as queer folks. And the reality is that embracing, I think, a clear politic that's an eye loyal towards the ends of liberation allows us some freedom. And also, I think, kind of the emperor has no clothes on, that all of the other structures that aren't clearly objective really do live inside of their own subjectivity. And so the kind of law as is, as an objective arbitrator doesn't exist. And naming the ways in which our politics influences how we operate feels really important as we move in a kind of act of honesty. So all of these liberation movements that I see kind of as culminating in this moment really take from this idea of transformation. And this is an MLK quote. I feel like if you quote MLK, you get a little bit of the we all in it together feel, right? And so even MLK recognized that what was necessary was not kind of reforms or twinkling at the edges, but actually a radical kind of formation of society. And so he said, and this is in response to the 1960s uprisings, in these trying circumstances, the Black Revolution is much more than a struggle for the rights of Negroes. It is forcing America to face all of its interrelated flaws: racism, poverty, militarism, and materialism. It is exposing the evils that are rooted deeply in the whole structure of our society. It reveals systemic rather than superficial flaws and suggests that a radical reconstruction of society itself is the real issue to be faced. And Ella Baker, who's another incredible civil rights leader and hero, similarly says, in order for us poor and oppressed people to become part of a society that is meaningful, the system under which we now exist has to be radically changed. This means that we are going to have to learn to think in radical terms. I use the term radical in its original meaning, getting down to and understanding the root cause. It means facing a system that does not lend itself to your needs and devising means by which you can change that system. And I love this quote because I think we often say radical and don't define it. But when we say radical, we mean really grasping at the roots of getting down to the underlying conditions that create the symptoms that we're living through and fighting against. And so I think I really see my lawyering and movement lawyering in this moment, in this era, as concerned with radical transformation of these systems, as has been demanded and indicated by civil rights leaders who have come before us. So I want to talk a bit about kind of movement lawyering as it pertains to transformation and abolition. And to do this, I want to just kind of ground this really quickly in abolition as a political theory, and specifically as it applies to lawyering and what that looks like and what that means. So movement lawyering for abolition requires, I think, an understanding of history and a denaturalization of police and prisons. And so we always start by saying that prisons and police are not natural entities, that they are creations of a state that's meant to control and often oppress Black and brown people. And the origins, the roots, right? So back to kind of radical, how do we grasp at the roots? The roots of policing and prisons in this country are, number one, in slave patrols. The prototypes of the first police forces are actually slave patrols, folks who were deputized to go and collect, to steal back, to re-enslave Black and brown people for economic gain. So that's the origins, the original, right, kind of police forces, slave patrols, which we see really echoed and shadowed in, for instance, like the Ferguson police force that collected money and debt from Black and brown people to really fuel the city. And so we see this link between kind of economic exploitation, Black bodies and control in police forces across the country. But that's the origins. The other origins are in the colonial origins, so on the kind of frontier, in genocidal aims of folks being deputized to really kill and oppress and steal the land of indigenous people. So this is the other prototype of policing. And then in the North, policing largely comes out of the suppression of labor strikes, of the hiring of first private security guards, and then the creation of public services who are called police to put down and to arrest strikes for the benefit of the kind of capital class, right? And so we just know that the roots of policing are inherently anti-Black, anti-worker, and anti-Indigenous. That those are the roots of it, that it's about controlling body, controlling labor, and really legitimizing and enforcing oppressive economic relationships, right? And we know, for instance, that the origins of mass incarceration and incarceration generally in this country come in the 13th Amendment loophole for slavery, so allowing the continuation of slavery under the name of incarceration, of like being dutifully convicted of a crime. And we see the use of this loophole through the Black codes and convict leasing. And so we see that white slave owners and the political class in the South take advantage of the 13th Amendment intentionally, as it was created, to ensure continued enslavement, continued economic deprivation of Black communities through the use of the criminal code in Black codes and convict leasing. And then we see the war on drugs, which is really a continuation of this struggle and this fight, and it creates literally thousands of new laws and criminal codes as a way to control and politically advantage the new majority, the silent majority of Nixon and the Reagan era. And so we yet again see the criminal code being weaponized against Black and brown people to ensure economic exploitation and political advantage, which is really the history in its entirety of incarceration in this country, is rooted in anti-Blackness, is rooted in anti-workerness. We also know that in this country, abolition or that mass incarceration is a huge problem. Literally millions of people incarcerated have gone through these systems. This is just a pie chart of how many folks are on local, state, tribal, and immigration and youth detention. These are human beings. And so we see these numbers in the millions. And I think we often forget, although those of us who have loved ones who are locked up don't forget, that these are millions of people's, millions of families' lives who have been interrupted, destroyed because of incarceration. And we, of course, know that in this country that it is racialized. And how could it not be, considering the roots of it? But this is just a chart to show how many people of different races are locked up. And then, of course, Black and Latinx people at higher rates in their population and white folks at lower rates in the general population. So the reality is that the US locks up more folks per capita than any other nation. While we represent 4% of the world's population, we're 25%, 22% of its prisoners, and we spend exorbitant amounts of money to do this. And so about $80 billion is spent annually to fund criminalization in this country, and another $115 billion is spent every single year on policing. And this happens at the expense of other social services. And so this is a map of local budgets and how much of those general funds are being spent on things like caging of human beings, surveillance, occupation of neighborhoods by militarized forces. And that comes at the expense of things like healthcare, of education, of transportation, of job programs, of employment programs, of youth programs. And so these are kind of ethical budget choices that we have made historically that have prioritized cages over care over and over again. And the reality is that cages and cops don't actually solve for the problems that we purport that they solve for. And so this is an amazing quote by Ruthie Wilson-Gilmore, who says, "Prisons and police are partial geographical solutions to political and economic crises and problems." And this, I think, is a really powerful and important quote, because the reality is that a number of studies have shown us that police and cages don't keep us more safe. That in fact, the only clear correlation between reductions in crime and like social services is actually jobs. That more cops don't reduce crime, more prisons don't reduce crime. A real living wage is the only thing that's been shown over a 10-year study to reduce crime rates in this country. And so literally we have built billions, trillions of dollars of infrastructure to cage people with no evidence that caging people keeps us safe. However, prisons have become the solutions, as have police, to things like poverty, to things like drug addiction, to things like mental health crises, to things like lack of education. And so we have posed and created these huge industries of prisons and jails and militarization to solve for problems that they don't solve for. And instead, they have become the solutions to problems such as poverty. And that has been reinforced by these cycles of spending that pour money into these things and take them away from other things. So I want to just quickly name, when I say abolition, I mean of the prison industrial complex, although I think there's a really robust and important conversation about abolition in a more kind of a larger sense of what does it mean, and this is from kind of Du Bois's writing, what does it mean to think about democratic, like democracy and abolition, to think about all the institutions, the Senate, the Supreme Court, the Electoral College that were created to sustain racial subjugation in this country and that are now deeply implicated in that mission. And so I think have been thinking a lot about kind of Du Boisian's analysis of what it means to think about abolition in a wider sense of what it would mean to have kind of democratic institutions that were not deeply implicated inside of slavery. And I think the prison industrial complex is the first kind of structure to abolish towards a wider vision of what abolition democracy might look like in this country. So when we say prison industrial complex, we mean the interdependent relationship between private and public interests, using imprisonment, policing, surveillance, the courts, and cultural tools to maintain social control and difference. So that is the PIC. And abolition of the PIC is a political vision with the goal of eliminating imprisonment, policing, surveillance, sentencing, and creating lasting alternatives to punishment and imprisonment. And this is all from Critical Resistance, who is an amazing organization who have led the way when it comes to abolitionist thinking. And abolition is as much about what we dismantle as what we create. And so very often I think there's a real, my topic focus on the kind of demands around defund or abolition is just tearing down prisons. And that is essential, but actually what's more important is what we put in instead. What are we creating instead of prisons to hold our people and to keep us safe? And so we often say that we're fighting not just for a world without prisons and police, but for a world that does not need prisons and police. And so how are we actually kind of trying to oversee and to support transformation of society beyond just the void or the lack of prisons, but in fact, how do we create alternative structures that really hold our people and keep us all safe? And defund the police, I think, is really the most recent iteration and the result of decades of work that is a demand around abolition, that it is focusing on the police as kind of the beginning of an abolitionist vision. And just the reality that, I was part of, I think, the movement of the last 6 years of the Black Lives Matter movement. And after the killing of Mike Brown, the demand was for body cameras. It was for actually things that increased funding to policing, that legitimized the police. And we see 6 years later, after this summer and another rash of police killings, a demand for defund. And that really is the work, the tireless work of countless organizers and advocates on the ground who really saw that things like body cameras and prosecutions were false solutions to much bigger problems. And so have demanded, I think, what is really a systemic and a transformative demand about we have to take money out of this system that is killing our people and put it into things that actually keep us safe in the long run. And so I say all of that to lay just a really quick groundwork for what we call transformative reforms. But I want to present those not just as a series of political decisions or reforms that we want to make, but also as a way of actually lawyering, kind of a remix of movement lawyering with an abolitionist feel. That how do we actually, as lawyers and legal workers, kind of step up to this moment and think about what does it mean? What are the implications for how we lawyer inside of these radical movements? And so transformative reforms is an expression often used inside of movement spaces. I think Amna Akbar and other lawyers and academics have kind of theorized about this, but it comes from abolitionist conversations and socialist conversations, like how do we actually make sure that reforms that we enact today result in lasting change, not just to a single material condition, but to the entire system. And I think transformative reforms have been created in opposition to what we call reformist reforms, which are reforms that legitimize the status quo and fail to address systemic flaws or root causes. And very often, inside of these moments of massive protest, of possibilities of massive change, of the uprooting of these structures, what we see is that the kind of politicians and often lawyers as well, honestly, come up with reformist reforms that don't actually radically change the system, that re-entrench it. And so I think a lot about Kimberly Crenshaw and kind of reform and re-entrenchment, this model of that the system is in many ways impenetrable to long-lasting change and transformation, because there are constantly these kind of small tweaks that are made that re-legitimize, that sanitize, that re-empower the system, as opposed to actually changing the logic of the system. And so reformist reforms are kind of the word that describes all the different reforms, whether it's body cameras, procedural reforms. They don't actually change anything. They kind of provide very small tweaks to the system, but in the long run actually legitimize the systems that we're working under. And this is in opposition to what we call transformative or abolitionist reforms. And these are reforms that not only change material conditions, they also shrink the system. The reforms that in their aim shrink the scope, the budgets of these systems. They also delegitimize the system. That they seek to find ways to change the kind of governing logic of these systems. They demand something that delegitimizes the narratives that really uphold these systems. They also assess and address past harms. So they think about what are the ways that this system has harmed people, has killed people. They refuse the idea that we can just kind of start over again with a reform and not look back. So they demand a looking back at the ways in which these systems and these laws and these things have harmed people. They also shift power. The reforms that continue to give the same players, whether they're judges or DAs or politicians, all the power. They don't push for democratic changes and who actually makes decisions and who has power, are not transformative reforms. They also make future reforms easier. And so there can be a lot of things that fall into the category of transformative reforms, but they have these characteristics. They improve material conditions, they shrink the system, whether that's budget-wise or scope-wise or reach-wise. They delegitimize the logics of the system in basic ways. They assess and address past harms. They look back, therefore. They also shift power, and they make future reforms easier, right? And so they make it easier to do something different. The next step, they open space and open doors for new reforms. I think it's not just the what, though, of transformative reforms, it's also the how. How do they happen? And so they happen through collaborative processes. They're not just lawyers in a room or lawmakers in a room. They happen through democratic processes that engage the folks who are most impacted. And then by engaging them, they really build power with them. They also happen through democratic and relational and accountable processes, right? And I think this accountable piece is huge. That they happen by actors who have relationships with and are accountable to people who are most impacted by these things. So they're not just theories or ideas, that they really are played through and they're done in collaboration with folks who have to live through the consequences of them. And the folks who are making the decisions are accountable in some direct ways to folks who have to live through the consequences. And they also often happen with the leadership of directly impacted people. And so transformative reforms, I think, like defund, a call to shrink the system, a call that is led by folks who have survived police violence, a call that actually brings folks into democratic processes to think about and decide what does keep us safe, what could defund look like, what could that be? That these are transformative, not just in the kind of the substance, but also in the process of how they happen. And it's really important, I think, to name that transformative reforms, although difficult to come by, can look like small steps. It's not that the revolution happens in a single kind of swipe, but it's how these reforms are happening, how we're engaging in them, what our goals are, and the ways that they, in fact, create more space as opposed to shrinking space, right? And these are important because the reality is that without a long-term vision, without some kind of commitment to reforms that change the system, that interrogate the system, that shrink the system, we really are destined to create tomorrow's tools of oppression. And I say body cameras a lot because I think it's a really powerful example of a reform that's forwarded as something that's supposed to be transformative. It was forwarded as like the movement is calling for body cameras. But the reality is that body cameras doesn't actually save anybody's life, right? And they increase police budgets, they re-legitimize police, and they don't actually solve the problem that we're facing. And so we see ourselves 5 years after a series of demands, and we see body cameras actually across the country. But of course, the murder of Black and brown people are still happening across the globe, right? Because body cameras don't actually address the root causes. They don't shrink the system. They don't delegitimize the system. They are really kind of a Band-Aid on what is a bullet wound. And so it's really important. And now many of us are fighting against body cameras as an extension of the surveillance state. And so it's important that as we think through what we want to change, what we think the call to action is from the mass uprisings, from this moment, that we think about reforms that actually are challenging the logics of this system and that are honoring the work and the liberation fights of many people who are on the ground and having these fights. And I think that this kind of these metrics of what constitutes transformative reforms and how we get those are helpful, not just for thinking about policy. And so really using this as kind of a checklist when we create policy. It's also helpful for us as movement or radical lawyers to think about these things as ways to engage in how we lawyer. And so, for instance, I think that it's important as lawyers that we ask ourselves as we're lawyering whether or not the work we're doing is improving the material conditions of our people? Is the work we're doing shrinking the system? Are we finding ways to really to shrink harmful systems, whether it is the criminal legal system or the child welfare system or the environmental system? What are ways that we're actually shrinking the system as we're practicing law inside of it? Are we delegitimizing the system? And not just in our kind of daily practice, but in our conversations, in our teachings, in our relationships. Are we using our privilege as lawyers to delegitimize systems that have historically and continue to harm our people, right? Are we using our tools and our privilege to do that? Are we as lawyers and legal workers assessing and addressing past harms in our work? Are we taking the frame of reparations to say we want to not just look forward, but also look back to acknowledge the ways that the law, that these legal practices have harmed these communities? And we want to assess that and think about ways we can be accountable for that harm. Are we in our legal practice shifting power? Are we actually relying on and trying to create new pathways of leadership development and power, not just for lawyers who are in this position, but for community members, for folks who are directly impacted, for our clients? How are we actually in our daily practice creating new pathways of power? And also, are we making future reforms easier? Are we creating conversations and opening space for our clients and our people and our partners that actually makes reform easier in the future? And are we doing all of this in a way that is in deep relationship with and democratic and accountable to communities who we're saying we're fighting for? And so I have found, I think, especially in the last few years, this idea of using this framework, not only for policy, but for lawyering and for practice, as really important, and think about how I want to show up inside of radical movement in this moment. And so I want to just end really quickly on this kind of thought, like what is the kind of future of movement lawyering? How do we think about that in meaningful ways? And so I think there's a few things that, at least for my reflections, have been really important. And so one is just being clear on our politics, that we are not apolitical beings. We're not operating apolitically, that in fact, when we say we're being apolitical or objective, we're doing harm to the reality that the current status quo is so anti-Black, so anti-woman, so anti-queer, that it is deeply harmful, and we perpetuate those realities if we're not deeply and explicitly political in our aims. Secondly, be part of a movement, join an organization, be part of something in this moment, that it will sharpen us and it assures our accountability to someone beyond ourselves or our own ideas. And so who are you accountable to happens in relationship with movement. Also engage in constant power analysis, including being aware of our own power and privilege that comes from our legal educations or positionality. Also work to delegitimize the system, even as you're part of it. Work to delegitimize it in basic ways. Think about ways that we can actually not just equate the law with righteousness or with justice. Constantly be challenging the idea that the law is the kind of highest power or highest good. And showcase creative ways to practice the law. What are ways that we can be bold and risky in our lawyering? What are ways that we can create more open pathways for folks to challenge and be present inside of legal frameworks in ways that actually are very bold and innovative? And so that's kind of my advice or thought to kind of this moment of movement lawyering, and think about how do we actually embrace radical movement abolition inside of a movement lawyering frame. So I will stop there, and thank y'all so much. That went long. So that was my mom's teaching and preaching in me. But it's been such a pleasure just to start this conversation. And I will turn off my share screen.
Great. Thank you so much, Marbre. That was such a wonderful, passionate, and thought-provoking talk. I feel like my energy level totally rising, which doesn't happen that often on Zoom, I have to say. So thank you. Let's turn to the next portion, which is going to be our Q&A. Many of us, and I think particularly the students that are on the webinar today, regularly wrestle with the many issues that you raised in your talk. And for the Q&A portion, we're going to be welcoming 3 of our current UCLA law students. They all happen to specialize both in critical race studies as well as public interest lawyering. And I'm just going to briefly introduce them and ask them to turn their cameras on, and we will have them up on the screen with you. And then I'll explain the format. So the 3 students are, oh, Corbin, you've been elevated to a 2L, but Corbin's actually a 1L, and he's pursuing a joint MA in African American Studies. And before law school, he worked for the Equal Justice Initiative and a criminal justice program in Michigan on prison conditions and other criminal justice issues. He's currently a Jane Kahn Prison Law Fellow for the UCLA Prison Law Program. And then we have two 2Ls who are joining us. Alana Kane is a 2L, also an intersectional activist and an aspiring legal scholar. She aims to disempower the entanglements of race, racism, and the law. She's editor-in-chief of volume 69 of the UCLA Law Review. She co-chairs the Queer and Trans People of Color Collective at the law school and is a fellow for Professor Kimberly Crenshaw, who was mentioned earlier by Marbre, as part of the African American Policy Forum. And last but not least, our other 2L is Jackie Park, who is involved in many student groups, including Tenants Law Association, the Queer and Trans People of Color Collective, APILSA, the API Law Student Association, NLG, and Law Review. She's committed to disrupting a legal system that favors displacement and incarceration, and is interested in connecting with others who strive to be attorneys on tap, not on top. So thank you to all three of you for participating today in between classes. And so for those in the audience, given the time, we're going to probably focus the Q&A on the questions that the students have, but I think they have questions that I think are reflective of what I think many of you may be thinking in response to Marbre's talk. And in particular, I think for many of us, sort of the struggle that social justice minded students and faculty feel regarding how law schools are structured and what the legal system values relative to what, why we do the work that we do, and have, the movements for broader movements for justice and liberation. So I'm gonna start, in the first round, let's start with Alana, and then Jackie, and then Corbin, and then we'll see where we are on time. And I will say, if you have questions, you can feel free to put them in to the Q&A or the chat, but given the limited time, I wanted to focus on the student panelists. And I wanted to thank Marbre for just suggesting this format as a way to bridge the inevitable Zoom webinar divide. So thank you to the students, thank you to Marbre. Go ahead, Alana.
Hi, everyone, and thank you so much for being here, Marbre. It's always such a pleasure to hear you talk, and I feel like I come away just writing furiously, just with new things that, I can ground myself in. One of the things that you've previously said before that has been, an anchor for me is that the law is the indoctrination of limitation. And I think that, it was really clear in your comments and, how the legal pedagogy in and of itself is structured and mapped onto these histories of white supremacy and colonialism and capitalism and heteropatriarchy. So I would love to hear from you about, thinking about, we know that the law will not save us. How do you think that we can sort of create these spaces to sort of just imagine radical possibility?
Thank you so much for that question and for all the dope work that you're doing at UCLA to create spaces. Thank you for that. I think not only is the law the indoctrination of limitations, I think the way that law school is structured is about reinforcing those and making so much impossible. So I even think about kind of the idea of precedent, which is like at the heart of so much of the work that we do in law school, is learning precedent, learning how to like regurgitate precedent, talking about the importance of precedent. And the reality is that the precedent is, of course, almost exclusively old white men. And certainly even, and as it's more Black and brown faces, it's still kind of the most conservative folks who reach benches, who can write those decisions. And so the idea of relying on what's come before as dictating what is possible now, I think is at the heart of that analysis. And I often think about, I went to law school as like a poet, and I thought I was a little bit radical, although it definitely radicalized me even more. And I realized that I left law school and I couldn't write poetry, that I got so used to this kind of format of writing in clauses and with like very clear rationale of every sentence, that it destroyed my ability to do poetry. And perhaps that's also my fault, so I'm gonna take some responsibility for that. But the reality is that so much of law is not only about indoctrinating you into the limitations of what's possible, but actually I think like shifting how your brain works and thinks about things. And so I think, the only solution to that is to be in deep community with folks who operate inside of different realities, who take as what we think as being impossible or undone as actually just the beginning of possibility. And so I often tell a story, which I think you probably have heard before, but about kind of my early legal experience and this realization that my mind was really limited in what I thought was possible. And so I was a baby lawyer. I was like 1 or 2 years out of law school, 2 years, I guess. And it was right after after Ferguson had happened. And I was going across the country because I was working for an organization who was doing police reform. And so I had kind of a list of like a checklist of things that I thought were like appropriate responses to police violence. So there was like oversight boards and like firing of cops and like a list of kind of top 10 things. And it had been developed with communities. Like it wasn't, I didn't just make it up. Like I talked to the people about it, but I thought it was a pretty holistic list of like what I thought was possible inside the law. And I actually went to Minneapolis, and it was Minneapolis 6 years ago was also aflame after yet another Black person had been killed by police. It was Jamal Clark at that point, a young man. And they had, the organizers that had occupied the precinct, like literally in the middle of the dead middle of winter, had occupied the entire precinct and wouldn't leave. And so they called me in to try and help them figure out demands and to write some language for an introduction to city council. And so I got there and I like gave a presentation. I was like, here are the 5 options, here's what we can do. And one of the young organizers who's now the leader of Black Visions Collective said to me, okay, well, thank you for that. We're actually interested in abolishing the police. What would be the first step policy-wise to do that? And I was like, shit. Like, I have no idea what the first step is. I hadn't thought of that as the goal of this conversation. And my instinct, in part because of law school exams, was to be like, nope, not possible. There's nothing here. I issue spotted. I can't find it. It's not possible. And so I think that I learned really early on, that like what I thought was radical, that my limitations were so dictated by my education, by my positionality. It was like a new middle class, you know, it was a whole thing. I had like a check coming in every month, that all of those things made me more risk averse in some ways and made what was possible really limited. And so I say all that to say, you have to be in deep relationship with folks who really are pushing themselves and the frontiers of what's possible, and in right relationship, that they trust you and you trust them to know and understand each other's limitations. I think secondly is that you're part of a community of organizers, that you are not just a movement lawyer who like you give your days to movement. You also are part in community with folks who are in movement. And so it's not just your day job. They know your baby's names, you know their baby's names, you know what you can cook for dinner, they know your phone number, that you're in relationship in a real way that I think grows you. And then lastly, I think that there's a pedagogy in law school, and I think critical race theory is so important for this, that you're constantly in your brain creating other pathways as you're learning the law, that it's just one of a few options of how you understand the world. I hope that answers your question.
Thank you so much. So for me, so much of lawyering is like working within the confines of the state, right? To do something about the immediate harm that like our people are facing. And I struggle with this so much, like being in law school, like the spiritual and the, you know, spiritual violence that we kind of accept abuse as access. And so much of getting the job means, you know, having to swallow our own dreams of liberation and self-determination. And so it's like deep, you know, ache and bruising. And so I see a lot of people kind of weaponizing identity politics, that kind of shift from the actual, like the roots of a lot of like Black women and womanness who've intentionally found community and strength in identity politics, right? As a tool to fight against the colonial project of the United States. So I was just wondering how you have worked through like with the complexities of identity politics and how it is, you know, like weaponized this, like even within like lefty spaces, since we all know that like kinfolk doesn't equal kinfolk. And same for like, you know, the continued terror that's enacted by white women under the guise of liberation for women, when it just means like liberation for women to also become imperialist. Yeah, it's like a long-winded way of asking the question of have you like been able to like manage that in like lefty spaces?
It's such a good question. I love this abuse of access idea too, of like what is required of us and what is done to us by just trying to access anything, like whether it's like justice or resources or, so just thank you for that. I have to sit with that because I think that's really powerful. Yeah, you know, I think that this is why the politics is so important, that at the heart of movement lawyering, which I don't actually think there's been enough kind of theorizing about, is an adoption of a clear set of politics. And your politics are not identity politics. The politics are about how you think the world needs to move and operate. They're about anti-capitalism, they're about anti-Blackness, about anti-racism, like that you adopt a really clear set of politics that define your practice and define your partnerships, right? And so I think that that's really important. I think very often lawyers talk about the politics as like being kind of almost constitutional. It's like this, like kind of like, oh, I believe in the Constitution. No, you like, what does that mean? Like, which part of it, and why, right? And so I think there's this real question of like, what are your political values? What is the highest purpose that you move with? And inside of that, you have more room for discernment around who is and isn't your ally. And that isn't actually about identity or experience even always, it's about shared politics. And with that said, I think it's also really important. I think we've seen the weaponization of identity politics that has happened actually through trauma as well, that people who have been traumatized then use this kind of weaponization. And so I think we should be in a constant kind of posture of what does it mean to bring folks into our politics and our movement in a way that welcomes them, that acknowledges the harms they've experienced, and says it's not sufficient that you come in this space harmed or because you've lived through that, you actually have to develop a politic as well. And I think, you know, I've seen song and movement groups across the country do this incredibly well of embracing both the trauma that might bring you to weaponization and saying like, nah, that's not cool here. And the way that we move is actually through a political lens. And so I think this is like, I can't emphasize this enough of it. I remember constantly in law school being like berated for being too political, like, oh, this is objective, like don't bring your, and it's like, no, it's not, like it's objective because you're a white man talking about a white man, like that feels objective to you, but it's actually not objective, right? And so I think this idea of being really clear about what is the political framework that that you feel allegiance to and how are you accountable to it, and then I think organizing with people and in spaces that also are aligned with that, and calling out the ways in which cultural feminism is harmful, the ways in which identity politics get weaponized, the ways in which like we can't actually move from a place of to healing if we're inside of that kind of trauma and if we're like tokenizing folks in that way. Thank you for that great question. And this abuse is access. I'm gonna like meditate on this tonight. I really think that's really powerful. I really appreciate that.
Hi, thank you so much for being here today and for the great lecture. My questions kind of ask you to put on your executive director hat a bit. And in thinking about, even in the radical progressive space, or particularly in the criminal legal space or organizations that engage with the criminal legal system, there still seems to be an overabundance of majority white organizations or white-led organizations that accumulate a lot of resources. Do you see this lack of particularly Black-led or majority Black organizations as a resource problem? How should we engage with philanthropy, if at all, or traditional philanthropy to deal with this issue and to actually create a space that is reflective of the populations that are most affected by these systems?
Yes. I think that it's a resource problem. I think it is a leadership development problem. I think it is a societal, like anti-Black, anti-woman problem. So I think there's a lot of ways in which like who feels like they are fit for leadership, who feels empowered to step into leadership is all dictated by the ways in which our society is framed. And I think it's especially philanthropy though, which are like the folks who become the gatekeepers of that kind of space. So I'll say a few things. One is, one of the most rewarding things I've been a part of in the last few years is the National Bailout Collective, which is a collection of mostly folks who've been incarcerated, of mostly femmes, of all Black folks who came together in the middle of kind of the bail reform fights that were really like privileging a bail reform that was reformist, as I discussed, like bail reforms that really legitimized the system, put band-aids on it. And they came together and decided they wanted to bail out Black mamas as a way to shine a light on the way this system is not only inherently anti-Black, but also the ways that these small incremental reformist reforms are actually re-incarcerating, re-cementing this system in ways that are really harmful. And so we came together, we were like a raggedy crew. There was like, I think 15 of us. We didn't have any money raised. We were like, we just have to do this. And we raised, I think, over $5 million from over 50,000 individual people. And that was like literally, like Mary Hooks tells a story about going to the car wash and a homeless woman coming up and saying, like, I only have $3 in my pocket, but I want to give you money to bail out some Black mamas. And like literally all people going into their pockets when they have so little to support our movement. And so I think we have to think about what are the kinds of ways that we're raising money, raising awareness, and like impacting our people so that they're showing up for us in a way that they're funding and supporting us. And so I think that's one of the major goals, at least for Black Lives, that we have, is how do we move away from foundation support, which gets, more, like the more radical, especially in the capitalists, I've noticed, you get, the more hesitant foundations are to support you. And so I think there's a real conversation about how are our people supporting us. And I think there's real leadership development of, like, we actually have to have our people in these places of power. We have to support our people and create new ways for our folks to show up and be able to show out. But I think it is absolutely a resource and a leadership development and like a cultural problem that we don't have more Black orgs doing this. And quite frankly, it's a white savior problem, that there's this narrative about who gets to be in charge of our salvation that happens over and over again. And I think a lot about kind of like the roots of cultural feminism, to your question, Jackie, and how that gets played out in this nonprofit world where people get funded to go into other people's neighborhoods and lawyer and move and walk and operate in other people's places without any experience or cultural like underpinning in those. And so that to me is all kind of part of this like savior complex that gets developed when we aren't resourcing our people, supporting them, or politically educating all of our people.
So I actually really hate that the clock says that we are nearing the end of the scheduled time, because I know for a fact that Corbin and Jackie and Alana had probably 3 or 4 more questions each and maybe more from just sitting in the talk. I do want to thank them for jumping in and asking these questions. I feel like we could have unpacked each of the questions. I definitely know that last one. I mean, we could do whole webinars and sessions on this. But I want to take this time to kind of bring us to an official close. And so I know it's hard to do in a webinar format, but I invite you to please first join me in thanking Marbre for gifting us with all of her amazing kind of experiences and wisdom today as our very first Spring 2021 Maggie Levy Fellow. And thank you to Corbin, to Alana, to Jackie for your participation. I do want to say, oh, and finally, I should be remiss to not thank again. I think she's actually joining the webinar and has been listening. Our UCLA law alum, Maggie Levy herself, whose support has made today's program possible. And then also to all of you for joining us. I did want to remind the UCLA law students who are in the audience that you will have multiple other opportunities, as Marbre referenced, to actually have more intimate conversations with her. We do have the career talk on Wednesday, and we have the office hours. So you have invitations for all of these. Please sign up directly for those appointments. It's your chance to kind of follow up with your questions, which I'm sure you have after listening to her today. And then I just want to thank everyone for being here and to wish you all a great week. And we will see you in the ongoing fight for justice, for racial, social, and other justices. And thank you for being here.
Thank you all so much.